Hi, Lee Phillips here. I want to talk to you about what we call a Spendthrift Provision Trust or a Spendthrift Trust. There isn't a thing called a Spendthrift Trust. What it really is it's a paragraph that goes into a trust, and it can be inserted in your living revocable trust or your land trust or your irrevocable trust. It can basically be inserted everywhere. As long as that paragraph is in the trust, that means that the beneficiaries, their creditors, their ex-wife, their mother-in-law, nobody can get to their interest in the trust. If the paragraph isn't in the trust, the spendthrift provision, if the spendthrift provision isn't in the trust, then the creditor, the IRS, the ex-spouse, whoever can come and get the beneficial interest in the trust. So it becomes a very critical provision in a trust. And it's just a paragraph long. Let me read some of it to you for a minute. Except as otherwise provided in this trust agreement, all payments of principal and income which are payable, so everything, or will become payable to the beneficiary of any trust created by this trust agreement, you can create sub-trusts under the trusts, shall not be subject to anticipation, assignment, pledge, sale, or transfer in any manner. So, the kid has his inheritance, he knows it's in the trust, and he wants to go out and buy a Camaro. And he says, okay, look, you sell me the Camaro, I'll give you my inheritance. I will assign my beneficial interest in this trust over to you. Can't be done. Just said, the beneficiary can't do that. It goes on. Nor shall any beneficiary have the power to anticipate or encumber any such interest. So they can't use it as collateral for a loan. There's a lot of money. I'm going to inherit $3 million from Dad. That ought to be pretty good collateral for a loan. Dad's going to die. He's 99. Give me the loan and you can use this as collateral. No. That just said we can't do this. Nor shall such interest, while in the possession of the trustees, be liable for or subject to the debts, contracts, obligations, liabilities, or torts of any beneficiary. So if the guy causes a big accident and he gets sued, he has to declare bankruptcy. His interest in this trust is not considered in that lawsuit judgment or the bankruptcy. This is a critical clause, guys. Such interest shall also be free from any claim, control, or interference of the spouse of a married beneficiary or the parent of a beneficiary. So, mom dies, her trust is set up and it goes to the children. The children are going to go to Dad. Even though he's the ex and we didn't like him, they're going to go to Dad. If this provision is in the trust, then the ex-dad can't come back and get the money. Now the trustee can use the money for the children's benefit, but the ex-dad has no right to get that money. Cool, huh? The spendthrift provision is a critical provision. If that isn't in the trust and your son is the contractor and he goes bankrupt, well, he's not going bankrupt today, but if he goes bankrupt 2008, then if the provision isn't in the trust, his creditors, his bankruptcy trustee, will set a current value on the trust. He's going to inherit $3 million, but that's not for 10 years. We can figure Dad's life expectancy on average. We can figure out what the value of $3,000 in 10 years is today. That will be included in the bankruptcy if this provision isn't in the trust. The provision is critical. I can't overstate that. Now, there isn't such a thing as a spendthrift trust. It's any trust that has a provision like this in it. So now you understand spendthrift trusts a little better.